Did you remove the thumb down? Yeah.
I'm trying to read it. I don't know why.
Yeah, you part of
Yes, absolutely. And you could see the art or something. I've never lost, but the first thing. So I want to.
All right, one for county person, their phone, you may enter, make sure the cell phones are off or on vibrate. And then if you have any behavior on, I don't know how to move them. Don't move your, any sort. You can.
About
The
them
clipboard, make
bill.
sure you. Make sure you do the clipboard, please.
What's in the
Everyone's sitting by a clipboard. We're just gonna go over a lot of information and I need y'all to pay attention. This is the wrong. I didn't even get it. I don't even get it. Okay. I don't know. Okay. All rise. County Court law includes now in session, Honorable Judge Terrence Holmes presiding.
Okay, you may be seated. Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felonies are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and state jail felony. And if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, The range of punishment is minimum. Life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, as I mentioned to you earlier, the offense that you have is a misdemeanor, so you don't have to worry about those type of punishments. Now, misdemeanors are divided into three categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, the class C misdemeanors are cases that start in the city court or the JP court. They come to this court when a person is found guilty in one of those courts and they appeal their case. So if they appeal the case, the case comes to this court, they get a whole new trial. Now, the range of punishment for a class C misdemeanor is fine only. The fine cannot exceed $500. An example of a class C misdemeanor would be not having your seatbelt, speeding, having expired license sticker. Those are class C misdemeanors. Now, the next highest misdemeanor is a class B misdemeanor. The class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or you could be given both fine and confinement. The highest misdemeanor, which is a class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. And the other type of probation is called adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record, and you may get what we call a non-disclosure. Non-disclosure basically means that your record is sealed to the general public, and in order to qualify, as I mentioned to you earlier, you have to successfully complete the probation, and then you may be able to get your record sealed to the general public. Now, the operative word is general public. And I said that because the government, there are certain government agencies that can have access, but most of the public is the general public. So the general public cannot have access to the your conviction. Okay. Are you here for arraignment? Okay, hold on a minute. Need to get him the bailiff get him a clipboard. Sir, you need to take off your hat here for arraignment too? Yes, sir. Okay, you need to have a seat in the back row. We need 2 clipboards.
Yes, sir.
Okay, there's a clipboard over here that you can get. Oh, you got one there? And there's one right here? Okay. Let me get this one to you. Okay.
Are you guys doing makeup?
Okay, now, as I mentioned to you earlier, there are 2 types of probation. One type is called unadjudicated probation, which does not result in a conviction on your record. And if you successfully complete that type of probation, you can get a non-disclosure, which means your record is sealed to the general public. Now, the other type of probation is called adjudicated probation. And what that means is you would have a conviction on your record. However, there's something that is called, judicial clemency. Judicial clemency means that the court or the judge can set aside your conviction. And if your conviction is set aside, you no longer have this conviction on your record. Now, in order to qualify for judicial clemency, a couple of things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on probation. And three, you have to be successfully discharged or let off the probation by the probation department. If those three things happen, I already get one. If those three things happen, then the court can set aside your conviction. Okay. Now, as a defendant in a criminal case, you have rights. And I'm going to go over some of the rights that you have as a defendant in a criminal case. One of the rights that you have is a right to have, the gentleman just came in, has a right to have an attorney. And what that means is you have a right to have someone to represent you, a licensed attorney. Now, the information about your right to have an attorney is on the clipboard that you have before you. I'm going to go over that clipboard with you. The first document on the clipboard is titled Judge's Explanation of Rights to Defendants Without an Attorney. Okay, does everyone have that document before you? Okay. Now, that document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first paragraph starts off by saying that if you want an attorney to represent you, you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. The next paragraph states that if you want an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first sign a financial or fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It is titled Jefferson County Affidavit of Indigency. Please turn to that document. And the first page of the document looks like this, and you would have to fill out, if you would like to request a court-appointed attorney, you would have to fill out the first page of this document. And on the second page of this document, you would have to fill out the top portion that is titled Defendant's Oath. And then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant. And then you'll stop. Okay. Now, if we go back to the judge's explanation, that first document, the next paragraph says that you may not speak to a prosecutor. Prosecutor is one of the assistant criminal district attorneys. We have 3 of them here in court. You may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. What that means is this. If you would like to waive your right to have an attorney, in essence, give up your right to have an attorney, if you would like to represent yourself, then at that point, you'll be your own lawyer. You'll have an opportunity to talk to one of the prosecutors to see if you can work out a plea bargain or settlement on your case. But you cannot do that unless you first sign the written waiver. The written waiver is the third document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, only individuals who will be desiring to represent themselves will sign this document. If you want to hire an attorney, you don't have to sign this, read and sign this document. If you would like to apply for a court-appointed attorney, you don't have to read or sign this document. Only individuals who will be waiving their right to an attorney and represent themselves. You have to read and sign the document. Now, going back to the judge's explanation, The second to the last paragraph states, and this is for individuals who like to represent themselves, that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. The last paragraph states that, and this is for individuals who would like to represent themselves, if you would like to waive your right to an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Okay, now at the bottom of this document, in bold letters, and it says defendant's choice. Mark initials next to only one choice. Everyone is gonna choose one of the 5 categories, okay? If you would like to hire your own attorney and have your case reset, then you'll place your initials on the first line to the left. And right here at the bottom, first line to the left. If you've already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Okay. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney, that is, give up your right to have an attorney to represent you and you would like to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that says, that's titled defendant, and you will date it today's date, March 25th of 2025. So, as a brief recap, first of all, everyone is going to sign this document, one of the 5 categories. If you would like to hire your own attorney, place your initials on the first line to the left, sign and date it. And that's it. That's the only document you have to sign. You don't have to sign nothing else. If you would like to apply for a court-appointed attorney, you'll place your initials on the third line, sign and date this document. Then you would have to go to the affidavit of indigence, fill out the first page, go to the second page. You're gonna fill out the portion that's titled Defendant's Oath and Unsworn Declaration by Defendant, and then you'll stop. If you would like to represent yourself, then on the judge's explanation, you'll sign the 5th, put your initials on the last line, the 5th line. And then you'll sign and date it. And then you have to read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Does anyone have any questions? Okay. All right. Now we're going to give you some time to fill out that paperwork, but before you start filling out the paperwork, I need to tell you about some other rights that you have. One of the rights that you have is a right to have a trial by jury. You want to go to trial, you have a right to have a trial by jury. Where those young ladies are sitting, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence that comes in. They will listen to the arguments of the lawyers. They will also retire to the jury room to deliberate, and they will decide whether to find you not guilty or guilty of your charge. You also have a right to waive or give up your right to have a jury trial. If you waive or give up the right to have a jury trial, then your case will come before the court or the judge in one of three ways. One way to come before the court or before the judge is by way of a trial. And somebody might be asking the question, how can it come by way of a trial if I waive my right to a jury trial, if I don't want to have a jury trial? Well, it will come before the judge by way of what we call a bench trial. A bench trial is a trial by judge only. The judge would be the judge and the jury in the case. The judge would apply the facts to the law, and then the judge will decide whether or not you're not guilty or guilty. Now, the other way that your case can come before the court, if you decided that you did not want to have a trial, either a jury trial or bench trial, you just want to take care of your case, we call that a plea. You could either plead guilty or no contest. If you plead guilty, you're telling the court that you committed the offense that you've been charged with. If you plead no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. That's what no contest means. So if you plead guilty or no contest, then your case will come before the court, and it will come before the court by way of a plea bargain, an agreed plea bargain. An agreed plea bargain means that you and the state, or you and your attorney in the state, have worked out an agreement to settle the case. And then it comes before the judge. The judge can do one or two things. The judge can accept or reject the agreement. Now, let's say, for example, y'all worked out a plea bargain agreement, and the agreement is for you to be on probation. And then the judge says, well, I reject that agreement. In essence, I'm not going to follow that agreement. If the judge does that, you have a right to take back or withdraw your plea of guilty or no contest. You could say, well, judge, since you're not following the agreement that I made with the state, I'm not going to plead guilty, no contest or guilty. I take it back. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and let's say within 30 days, because I say 30 days because you have a right to appeal within 30 days, and let's say within 30 days you decided to yourself, you know what? I think I've been wrongfully convicted, or the court committed an error by convicting me. I'd like to appeal my case. And if that's the case, you have to come to the judge to get permission to appeal your case, if he follows the plea bargain agreement. So if the judge gives you permission, your case is going to leave this court and go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. There are 4 judges up there, 4 justices. They will review your case to see whether or not you've been wrongfully convicted, or to see whether or not this court committed an error by convicting you. Now, they can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. All right. Now, if they deny your appeal, you can appeal it to a higher court than them. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review, and I'll explain that to you. Pro se means you're representing yourself. You do not have a lawyer. And you'll be petitioning or asking the Texas Court of Criminal Appeals to review your case, to see whether or not the Ninth Court of Appeals erred by not granting your appeal, or whether or not this court erred by wrongfully convicting you or by committing an error. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can just simply find you not guilty. Case over. Or if they deny your petition, then at that point, your conviction will stand. Now, the other right that you have, besides having a right to have an attorney, right to have a trial by jury, right to have a bench trial, right to have an agreed plea bargain agreement. Let's say you're in the state, or you're in your attorney, or you're an attorney in the state, the district attorney's office that talk to try to work out a plea bargain, but y'all can't agree. Okay, you want to plead guilty, but y'all can't agree to what the punishment is. Well, you can go to the judge on what is called an unagreed plea bargain, which means that the judge will decide what the punishment will be based on the punishment, anything within the punishment range of your offense. All right. Now, the other right that you have is a right to call witnesses to your case. Let's say you go into trial, you want a witness. What's the right to call witnesses? Witnesses sit in that chair where that microphone is. We call that the witness stand. And what witnesses do, they can testify for you or against you. If you're representing yourself, you can ask some questions, or if you have a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. You also have a right to waive, which means to give up your right to have witnesses. Now, if you waive your right to call witnesses, that means you will not be calling witnesses. Does not mean that the state won't be calling witnesses, because they will be calling witnesses. Now, you also have what we call a Fifth Amendment right against self-incrimination. A lot of times we watch television shows, Law and Order, and some of the other shows about law on television. And we see where a person may be on the witness stand, or we see where a police officer goes up to a person to ask him questions, and the person says, "I take the fifth." And that's what they're saying. I'm not gonna testify. I don't have nothing to say against myself. I'm not saying that. Okay. You have a Fifth Amendment right against self-incrimination. What that means, the Fifth Amendment of the United States Constitution gives you the right to remain silent. You don't have to say anything. Okay? Police can ask you, some you say, "I take the fifth." Okay, you have a right to do that. Now, you can waive your Fifth Amendment right against self-incrimination. If you waive your Fifth Amendment right against self-incrimination, that means that you're not saying anything. Now, if you don't waive it, the state, the district attorney's office, the government cannot force you to take the witness stand and testify against yourself if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, the other right that I'm gonna talk about that you have a right to have discovery. It's just a word that means you have a right to see what's in the state's file, to see the state's evidence. You right to discover or see the state's evidence that they have against you. Now, you have a right to see witness statements, your statements, police reports, lab reports, photos, video recordings, listen to audio recordings. You have a right to see documents, have access to instruments, or any type of evidence that they have and will be using against you. You have a right to have access to that. We call that discovery. Now, you also have a right to waive or give up your right to have discovery, which means that you're saying that I don't want to have access to it. Okay? You'll be waiving your right to have discovery. Now, the next thing I need to talk about is this. Everyone that's here for arraignment, charges was filed on, you've been arrested, placed in the Jefferson County Jail, you're bonded out of jail, and you're either out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a PR bond or a personal recognizance bond, which means you did not have to pay anything to get out of jail. You were just released under your own personal recognizance. Now, every day that you spent in jail, every day that you spent in jail can be used as credit towards your punishment. Now, I said every day. Now, let's say you was booked in jail at 11:59 p.m. on last night, but you booked out of jail at 12:01 a.m. this morning, 2 minutes later. Okay? That's 2 days. Why? You get 2 days credit. Why? Because it's 2 different days. All right? And so every day that you spent in jail, you get credit for that time towards your punishment. So for example, let's say you spent 5 days in jail, the state is offering that you serve 5 days in jail. You would not have to serve any more time in jail. Why? Because you will be given credit for the time that you've already served. And so therefore you will not have to spend any more time in jail. Now, every day that you spent in jail also could be credited toward your fine and court costs. You will receive $100, you receive $100 credit toward your fine and court costs. So for example, if you spent 5 days in jail, that's $500. That can go toward your fine and court costs. If the state is offering you fine and court costs to settle your case of $500, that means you don't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, you will get what we call your fine and court costs will be taxed and retired. You don't have to pay it. Now, if they offer fine and court costs of 7 days of $700, that means you would have to pay $200 because we will subtract 500 that you already have from the 700 and at least 200, and you'd have to pay $200. Now, if you cannot pay the $200, no problem. We could put you on what is called a payment plan, where you can pay off the balance so much a month until it's paid off. Now, you may not have a job, or you may not have the income to pay the $200, no problem. We can convert the fine and court costs to community service. You will receive $12.50 credit toward every hour of community service that you perform in a nonprofit organization in our community. So if you work 8 hours a day, that's $100. So in our scenario where you're $200, you work 2 8-hour days in a nonprofit organization, that's $200. Case is over. You satisfied your sentence. All right. Now, Jefferson County has a program. When I say Jefferson County, I'm talking about the district attorney's office. They have a program for first-time offenders. Have been in trouble before, first time getting in trouble. What they would do, that program is called pretrial diversion. They would dismiss your case. Okay, and you could get it wiped off your record. We call it expunged. The way it works, it has to be the first time getting into trouble. Cannot be an offense for unlawful carrying a weapon of resisting arrest. And you have to have an attorney to assist you at getting into the program. You get into the program, case dismissed, you complete the program, you can get it expunged from the record. Expunged, it means erased, deleted, or wiped off. It's gone. Okay? So let's say the offense, your record look like this. Okay? When it's expunged, it looks like this. Okay? And so that's the program they have for individuals who haven't been in trouble before. If you're interested in that program, just let us know and we'll direct you. We'll be able to give you the information that you need to get into that program. Now, the district attorney's office has another program that is called Veterans Court. It is programmed for veterans only. Only thing you have to do to get into that program is be a veteran of any one of the branches of the United States military. Okay? And with that program, you get into the program and complete the program, they'll dismiss the case, and then you can get what is called a non-disclosure. And what a non-disclosure is, your record is sealed to the general public. And as I mentioned to you earlier, the general public cannot have access to your record. And again, it's called Veterans Court, and all to get in that program, you just have to be a veteran of any one of the branches of the military, any one of the United States military forces. And if you're interested in that program, we have information that we can give to you to assist you at getting into the program. Now, this court, County Court at Law Number 2, has a program that is called the Community Safety Initiative, or the CSI program. It is a program that God led me to start within the first 100 days of taking office in March of 2017. That program is designed to address the issue of what we call recidivism. Recidivism was where people commit crimes over and over and over. And it's basically a cycle. And the cycle usually starts where you don't have an education, can't get a job. You can't get a job, you usually get depressed. Once you get depressed, you turn to drugs and alcohol. Once you turn to drugs and alcohol, you eventually commit a crime. And once you commit a crime, you eventually get caught and do time. And then once you do time, you get out. And guess what? You're back in that same old cycle. Okay. So in order to break the cycle, we have our community safety initiative or the CSI program. And with that program, we have partnership with local agencies in our Southeast Texas community. And one of the agencies that we have a partnership with is a Spindletop Center. And we have some folks from Spindletop Center who's here this morning. They're going to come to you in a few minutes and tell you a little bit more about the program that they have to offer. But basically, Spindletop has an expertise to address mental health needs. Now, in order to qualify for the program, you do not have to be incompetent or insane. You could merely suffer from anxiety or depression, like any other host of mental illnesses. And they have the expertise to address those issues. And basically, what Spindletop will do today, well, today they have the ability to do a interview, okay? Either in our jury room, they can do it at their facility, by telephone, whichever is convenient for you. And it'll be a private interview that they will conduct. They also have the ability to do what is called an assessment to determine what the problem is, what your mental health issue is. And they can develop a treatment plan for either outpatient or inpatient to address your mental health needs. Spindletop also has a program that is called ATAR. A is ATAR. It's an acronym that stands for Addiction, Treatment, and Recovery. We have a partnership with our local drug and alcohol council that has a program that is called ATAR. That's called OZAR. OZAR is OSAR. That's an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol treatment or recovery program. And what they would do a screening. They can do an assessment and develop a treatment plan for either outpatient or inpatient to address your substance abuse issues that you may have. If you are unemployed, that is, you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. The Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas, they will help you to get a job in the area that you're trained in. Now, a lot of times individuals have training and they go apply to a place and go to several places, they can't get the job. Could be because they might have a criminal record or whatever. But with this program, you don't go on your behalf, they go on your behalf, and you get the job, right? Because they will vouch for you, okay? Because they have the reputation of training people, and those people that are trained are fit for the job. All right, now, if you have not graduated from high school or you do not have a GED, CIC also have a GED program where you can get your graduate equivalent to the diploma. Now, all of these programs that I just mentioned won't cost you anything, it's free. Only thing that will cost you is time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes because they have too much to lose. And so I like to say that when you come to county court at law, number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we have brochures that we can give to you, and we can, where you can get into any one of the programs that I just mentioned. Now, as I mentioned to you earlier, we have some folks from Spinatop that's gonna come before you and tell you a little bit more about the program that Spinatop has to offer. We have Deputy Berry and we have Caitlin. They'll tell you more about the program that Spinatop has to offer.
Thank you, Judge.
You're welcome.
Hello, ladies and gentlemen. My name is Patricia Berry. I am a peace officer licensed by the state and commissioned by Jefferson County Sheriff's Office. This is my partner, Caitlin. Caitlin is a qualified mental health professional with Spinatop Center. Now, the reason that we're here today in this courtroom is because the judge cares about each and every one. It comes from one bench. And he also understands that sometimes people who have legal issues commonly suffer from mental health needs or substance use issues, or maybe just a lack of resources. And that's what we're here to offer you today is resources. My partner Caitlin is going to explain to you the paperwork that we provided with you with that clipboard, and then we'll go from there.
At the top of the paper, it is basic information. It's name, birthday, phone number, and email. We need those things to put you in our system and to be able to contact you. Under that is how would you like to be contacted, and the options are call, text, or email. Whatever you check on the box is how I will contact you. I will not contact you unless it's checked on this box. Underneath that is what you need help with, and most of them are resources that I email to you. They're links and websites. You'd have to do them yourself. You'd have to pursue them yourself. But if you were to check mental health, which could be depression, PTSD, or anxiety, or you to check substance use, which could be any type of drug, alcohol, then you'll work hand with Spinatop, and we can get you the resources, the support that you need regarding those 2 things. Everything else is pretty much self-explanatory. If you want to talk to me in person today, you can write anywhere on your paper, please talk to me today. The judge will call you up, and then when he's done with you, I will come get you, I'll pull you to a back room, and then we can talk. Or if you want me to just call you, then just write that on the paper as well.
Now, ladies and gentlemen, understand that this is voluntary only. This is voluntary only. You do not have to fill this out. This is not mandated by the court. This is just something for us to offer you. It's a resource. And the very first resource that we're going to provide you with today is this card. On the back of this card is the 24-hour, 7-day-a-week crisis hotline number. If you find yourself in a dangerous situation, please call this number. Please reach out. We'll have a qualified mental health professional on the other end that can speak with you and hopefully get you the help that you need. Now, in a few minutes, we're going to be picking up that paperwork. And if you have any questions, go ahead. Thank you for your time. Thank you, Judge.
Thank you, Deputy Mayor and Caitlin. Okay, now, ladies and gentlemen, in a few minutes, we're gonna take a recess. And At that point, you'll have an opportunity to finish filling out the paperwork. Now, if you need help with filling out the paperwork, we have our court personnel, including myself, who will be happy to assist you with filling out the paperwork. Now, it's gonna take a few minutes to fill out the paperwork. If you need to use the restroom, there are two restrooms right outside in the hall. We have the male restroom or the men's restroom is in front of County Court at Law number 3 in the opposite hall, opposite side of the hallway. We have, the women's restroom, which is in front of the 172nd District Court. You'll be allowed to use the restroom and go out into the hallway. Now, please do not leave the courthouse. If you leave the courthouse, your name is called, you do not answer, your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest, you'll be arrested, and we'll have to go through this all over again. Okay? So it's just gonna take us a few minutes to get through the paperwork. And then once we get through the paperwork, we're gonna call you up before the bench, one at a time. Okay? Now, the folks from Spillertop, they're going to come back out into the gallery and, to pick up the paperwork that they have on the clipboard from you and then answer any questions, that you may have. So, at this time, the court is going to go into recess. And if you need help with your paperwork, just simply raise your hand and we'll get someone out there to help you with your paperwork. Court is in recess.
Make sure you complete your paperwork before you go out.
Oh, and just, and a note on that first document that is titled, Judge's Explanation of Rights to Defendants Without Attorney, you're gonna print your name on this top line right here. You're gonna print your name on this top line. Okay? All right. Go to be in recess.
This defendant is incarcerated in our facility,
I saw that on there.
so he's not. Or so I printed out that paperwork if the court wants it.
Yeah, I saw a note on there. Please come to the bench. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 24-CCCR 2414. Case is styled State of Texas versus Melissa Noel Van Loo. Van Loo, would you please come forward? Ms. Van Loo, your full name is Melissa Noel Van Loo? Ms. Van Loo, would you please raise your right hand? Your other hand up. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Van Loo? That's good. Ms. Van Loo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to hire your own attorney? Ms. Van Loo, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Ms. Van Loo, I read your answers. Now, Ms. Van Loo, our court coordinator is going to reset your case. Once she resets your case, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Okay. Next case is cause number 24-CCCR 2572. Case is styled the State of Texas versus Rashid Gonzalez. Mr. Gonzalez, your full name is Rashid Gonzalez? Rashid Gonzalez. Mr. Gonzalez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gonzalez, you may put your hand down. How are you doing, Mr. Gonzalez? I'm doing fine. Thanks for asking. Mr. Gonzalez, I have before me a document that is titled misdemeanor, well, it's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to hire your own attorney? Mr. Gonzalez, before you signed and initialed this document, did you read the document? You understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Gonzalez, your case is going to be reset to give you an opportunity to hire your attorney. Our court coordinator is going to reset your case. Once she gives you a reset, you'll be free to go. But before she gives you the reset, I need to give you some bond conditions. A bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. You see that document? And I'm going to go over this document, which it states as follows. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. You understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number 4 does not apply. That only applies in the DWI case. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 7, the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition? All right. Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. The court coordinator is going to reset your case. She can give you information on where you can get the global positioning monitoring system. Okay? All right. Please stand in front of the court coordinator. Well, have a seat in that first chair. Jamarian Jones. Mr. Jones, your full name is Jamarian Randall Jones. Mr. Jones, would you please raise your right hand? The other hand, sir. You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Sir. Okay, you may put your hand down. Mr. Jones, how are you doing? That's good. Now, Mr. Jones, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state that you would like to hire your own attorney? Now, Mr. Jones, before you signed and initialed this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Jones, your case is going to be reset to give you an opportunity to hire your own attorney. But before that is done, I need to give you some bond conditions. Okay, Mr. Jones, the document that has just been handed to you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document? Do you see the title? Okay, I'm going to go over this document with you, and it states as follows. Following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And do you understand that condition? And condition number 3 does not apply. Condition number 4 does not apply. However, on the next page, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possession of firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? Now, Mr. Jones, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay. Now, Mr. Jones, again, your case is gonna be reset. Have a seat in that first chair and wait for your name to be called. Huh? Yeah. Is that the one for? This case is, cause number M 331 182, case of style of state of Texas versus Alana Dania, Danica, Swallow. Ms. Swallow, would you please come forward? Do we have our paperwork? Ms. Swallow. Okay. Now, Ms. Swallow, before we get started, you have a right to have a court reporter to type down everything that's being said. Do you want a court reporter, or do you waive or give a right to have a court reporter to type down everything that's being said? I don't,
I can have a quick one to type down.
okay. Just have a seat. We can get a court, get a court reporter to, type down the record. Is this man? I came up like that.
What about me then? It's okay.
If, that's up to you.
It's okay. I'm ready to go.
Okay, that's fine. Okay, let me, my tablet came up. It didn't come up right. Okay, let me get to your paperwork. That door is locked. You gotta go to the other door. in Jefferson County, Texas, that you committed the Class A misdemeanor offense, possession of a controlled substance, penalty group 3, less than 28 grams. Mr. Wilson, do you understand what you have been charged with?
Sure.
And to this charge, how do you plead guilty, not guilty, or no contest? Guilty?
Guilty.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay, Mr. Wilson, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there's a set of initials on the line next to a box that says guilty. Did you place your initials on this document? And on the next document, on the same document, but the next page, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document. And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And I also have before me on paper a document that is titled Discovery Certification. Do you recognize this document?
Sure.
And is this your signature on the line that's titled defendant?
Very good.
And Mr. Wilson, before you sign and initial all of these documents that I've just showed you, did your attorney go over these documents with you?
Sure.
And did you understand everything that your attorney went on? Is everything in these documents true and correct to the best of your knowledge?
It offers states one.
Any objections?
No objection, Your Honor.
No objection. States exhibit number 1 will be admitted. And again, Mr. Matuska, you advised and counseled Mr. Wilson. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir.
And Mr. Wilson, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Sure.
Has he provided full, effective, and competent legal representation? Mr. Wilson, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred probation, fine is to be waived, 40 hours community service and court costs. This is running concurrent as well with the felony cost opinion.
Okay. What, the court appointed is 50, 277, crime lab, 100. Okay. Okay, Mr. Wilson, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you will not be required to pay a fine. The fine is going to be waived. You will be required to pay court costs of $277 you're required to pay a $100 lab fee, crime lab fee. You'll be required to reimburse Jefferson County Court appointed attorney's fees of $50. You'll be required to pay a reimbursement fee of $50. Now, the probation fee of $60 a month, in this case, you won't have to pay it because you paid it in the other case. And your analysis fee of $15 a month, you will not have to pay it in this case because you paid it in your other felony case that you have probation on. So instead of paying $122 a month, you'll be required to pay $40 a month. Will you be able to pay the $40 each month? Okay. You'll also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. This case will run concurrent with cause number 23 DCCR 1803 and cause number 23 CCCR 0952. Mr. Wilson, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Wilson, I'll follow the plea bargain agreement that you have entered into this case. Now, Mr. Wilson, if you successfully complete probationary periods in these cases will be dismissed, not result in conviction in your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Okay, now, Mr. Wilson, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. Okay, you're welcome. Ms. Swallow? Okay,
I need to get her to sign something else.
not, well, it's gonna be page 2. Yeah, it's 3-page document, right?
Right,
On page 2, the top left-hand corner, it says defender's signature.
okay, I'll.
Okay. Now, Ms. Swallow, I have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And Ms. Swallow, before you filled out this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Swallow, the court is going to find that you are indigent. Yeah, based on the finding of indigency. Hold on a minute. I know what it is. This one is a little different. This one is a little different. Okay, now let's see. That comes out to. That's 537. Okay. Now, Miss Swallow. The court is going to find that you're indigent pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The fine and court costs, I guess the balance of fine and court costs, which is $537. Well, let me explain. You have a $300 fine plus court costs of $337, which comes to a total of $637. The state is giving you 1 day credit, so we're gonna, which is $100. So we're gonna track $100 from the 637, that leaves 537. The court has found that you're indigent, and pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the $537 will be converted to 43 hours of community service that you would have to perform. Okay? And that community service is going to be performed here at the Jefferson County Courthouse. Do you understand? Okay. Now, do you understand this, the state's offer? And do you accept the state's offer? Okay. I'll follow the plea bargain agreement with the finding that you are indigent and your fine and court costs will be converted to 43 hours of community service that is performed at the Jefferson County Courthouse. All right? Just have a seat. We're going to do the paperwork.
Yeah, you're gonna tell them when to start.
Yeah, we'll give that to you because we'll have to get with the folks downstairs. They'll
I
be,
need to know because going to labor next month, so I need to make sure that it's at least after I have completed.
okay,
It will be fine.
okay. Okay. Didn't know that you were expecting. We hope that you have a healthy baby.
Yes, sir.
You know what it is?
Yes, sir.
What is it?
My first girl.
Girl, oh, congratulations.
Thank you.
Okay, congratulations. Now, what we're going to do is we're gonna reset your case. I'm gonna have to give a time to, we're gonna have to figure out a time that you should have it completed by. Okay? We're gonna have to take in consideration, I think you expecting, when you're expecting, so we're gonna have to develop a timetable for that, okay? So just have a seat and we'll be able to figure out something.
This misdemeanor is the underlying,
Basis for the MTRP.
yes, sir.
Now,
And he
when is,
pleaded not true today, so they're resetting him for a hearing.
when is do we have a
Don't know
court date?
yet. They said they would let us know this afternoon.
Okay, so what we'll do is we'll have our court coordinator to check the computer. And once we get a date of the felony, we're gonna set this on the same date,
Perfect.
okay?
Thank
So you're free to go. You have a blessed day.
Thank you, Your Honor.
All right,
See you guys tomorrow.
okay.
Judge, can we do, Mr. Landry, or he can go to the jail?
Who?
Follow. Reed Landry.
Oh, that
I
is
had a
good.
transfer waiting.
You say Landry?
Yes, sir.
Carlo Landry? Okay, Mr. Landry, your full name is Carlo Landry?
Yes, sir.
Mr. Landry, or Carlo, what's that, Richard Landry?
Yes, sir.
Mr. Landry, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Landry, you may put your hand down. Mr. Landry, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
And Mr. Landry, I have another document before me. This document is titled Jefferson County Affidavit of Indigence. You recognize this document? You can put your mask back on. On page 2 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Mr. Landry, before you signed and initialed these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Landry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. She's gonna give it to the bailiff, and you can follow the bailiff, and you have a blessed day. Yes. You keep your mask on, sir.
I have a choice. So I would-
You have another charge.
Yes.
Well, that's the case, you have a warrant. The new
Yeah.
case.
So
Oh, yeah, it's, the warrant is on the new case.
But I'm gonna appoint Mr. Jones on both of them.
Okay, yeah, the attorney is gonna be appointed on both of them.
yes, I was saying you can go ahead and my bill. No problem.
Well, they'll set that at, that we have a magistrate at the jail that would do that.
I'm sorry,
Okay.
possible way you can do it now. 'Cause I-
The magistrate at the jail would do that. That's why we have a magistrate at the jail. That's his job to do, okay?
Would I have to-
Okay, when you get there, they're gonna inform the magistrate, and the magistrate could set your bail.
Also, they're gonna automatically do it when I get it there.
Yeah, once they let them know, you can just tell them, we can make a call to them to let them know that you over there in custody, they need to set your bail. Okay. No, I mean, he's over there now. Okay, he works 9 to 5.
Yes, sir. All right.
Okay, so make sure we get a call and let him know. Okay. All right, Linda Simon. Come forward. Ms. Simon. Your full name is Linda Simon? Simon, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Simon, you may put your hand down. How you doing, Ms. Simon? I'm doing fine. Thanks for asking, Ms. Simon. I have before me 2 documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Simon, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Simon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Before I give you that information, I need to give you some bond conditions. Would you please step to your left to get these bond conditions? And you need it. Okay, now, Ms. Simon, do you see the document that's in your hand that's titled Standard Bond Conditions and County Court at Law Number 2?
Yes, sir.
I'm gonna go over this document with you, and it states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not, condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply, however, condition number 5 does apply, and condition number 5 states as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Ms. Simon, if you violate any one of these conditions, your bond will be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now, Ms. Simon, please have a seat at that first chair on the wall. Wait for your name to be called. Yeah. Okay, just hold on. We're gonna have to put it in there that a fine was, you come to the lady, a fine was converted to community service, and a community service shall be performed at the Jefferson County Courthouse. Okay, and then we're gonna have to say, yeah. And she'll provide proof to the court. Okay, next, James Harris. Okay, this is cause number M332080, case of style of state of Texas versus James Willie Harris. Mr. Harris, is that your full name? Mr. Harris, would you please raise your right hand? Mr. Harris, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Harris, you may put your hand down. How are you doing, Mr. Harris? That's good, Mr. Harris. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Or these your initials on the line that state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature? Ms. Harris, Mr. Harris. Okay, Ms. Harris, do you before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Harris, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you the information, they need to give you some bond conditions. This document is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document?
Yes, sir.
Okay, now, Mr. Harris, before you signed, well, I'm going to go over this document with you. And this document states, following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number 4 does not apply. However, on the next page, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
And condition number 7, defendant shall wear a global positioning monitoring system device at defendant's expense, with written verification being submitted to the court within 3 days. Do you understand that condition? Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay. Now, the court coordinator is going to give you information as to where you can get your global positioning monitoring and how you can get that proof to the court. Please have a seat in that first chair on the wall and wait for your name to be called. Isabel Marie Ventura. Isabel. Your name is pronounced Isabel Marie Ventura. Ms. Ventura, would you please raise your right hand? Ms. Ventura, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Ventura, you may put your hand down. How are you doing, Ms. Ventura? I'm doing fine. Thanks for asking. Ms. Ventura, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? Ms. Ventura, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Ventura, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you'll be free to go, and you have a blessed day. Have a seat in the second chair on the wall. Tawana Jeanette Jackson. Ms. Jackson, your full name is Tawana Jeanette Jackson.
Yes, I just want.
Ms. Jackson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I am.
Ms. Jackson, you may put your hand down. How are you doing, Ms. Jackson? I'm blessed as well. Thanks, Jackson. Ms. Jackson, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Ms. Jackson, I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? And on page 2 of the same document is a signature on the line that's titled Defender Signature. Is this your signature?
Yes.
Ms. Jackson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Jackson, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day.
Yes, sir.
Please have a seat in the first chair on the wall. Eric Mata. Eric Mata Senior. Mr. Mata, your full name is Eric Rodriguez Mata Senior. Mr. Mata, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Mata, you may put your hand down. How are you doing, Mr. Mata? Okay, Mr. Mata, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You need to do you recognize this document? And is this your signature on the line that's titled Defender? And are these your initials on the line that's titled, you like to apply for court-appointed attorney? I also have another document that is titled, Jefferson County Affidavit of Indians. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature? Mr. Mata, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Mata, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Don Boudreaux. Attorney Boudreaux will give information to contact you, and you will also be given information to contact him. But before our court coordinator will give you that information, but before she gives you the information, and they give you the bailiff is going to give you some bond conditions. I'm going to go over these bond conditions with you, Mr. Mata. This document is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
And it states as follows: following return of the criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Sir.
Now, condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go to any residence, school, or other location that frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possession of firearm ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest, or you'll be arrested and placed in the Jefferson County Jail. Do you understand?
Sir, for the misdemeanor, sir. The misdemeanor, right?
Yeah, would you have a felony or something?
No, I'm just saying.
Yeah, did you, when I was going over,
Dismissed today, that's all it was, sir.
huh?
I thought it was gonna be dismissed today, that's all it was, so.
Oh, no, your case is not being dismissed.
Obviously.
You probably need to, whatever you need to discuss, you probably need to discuss that. You can discuss that with your attorney. He'll be able to give you some advice on that. All right, you can have a seat in that third chair on the wall. And Mr. Slaughter, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Now, Mr. Slaughter, we have two cases. Let's see, that's 5-1 and it's 8-0. It's cause number 23CCC Aura 0951 and cause number 23CCCR 2180. Both cases are styled the state of Texas versus Trevani Slaughter. And Mr. Slaughter, would you please raise your right hand? Mr. Slaughter, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Slaughter, you may put your hand down. How are you doing, Mr. Slaughter? That's good. Now, Mr. Slaughter, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Or these your initials are on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? And Mr. Slaughter, before you signed and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Slaughter, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. Attorney that will be appointed to represent you in this case is attorney Tom Burbank. Attorney Burbank will give the information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. Dallas Clavel. Mr. Clavel, how are you doing? Mr. Clavel, I have before me a document that is titled, well, first of all, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. Mr. Clavel, your full name is Dallas Clavel Jr.? Mr. Clavel, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Mr. Clavel, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
I did and I did.
Okay, what you say you did and you didn't.
Well, first of all, Your Honor, I figure I was falsely accused of petty theft.
Okay, Mr. Clavel, I'm asking you about the affidavit. I'm not asking you about the facts of the case.
Yeah.
Okay, my question to you is, before you sign, and let me do this here before I go any further. You have a right to remain silent. Anything that you say can and will be used against you in the court of law. You have a right to have an attorney before and during any questioning. Do you understand that?
Yes.
Okay. So at this point, I'm not asking you about the facts of the case because you may make statements that could be incriminating. Okay. And so you have an attorney. Your attorney will be able to give you the advice that you need. All right. Now, again, before you sign and initial these two documents, the judge's explanation and the Jefferson County Affidavit of Indigence, did you read the documents?
Yes.
Did you understand everything in these documents?
Yes.
Okay, and is everything in these documents true and correct to the best of your knowledge?
Yeah.
Okay, now, Mr. Clavel, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Reuben Cartwright. Attorney Cartwright will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Okay.
Have a seat in that first chair on the wall, on that first chair on the wall. Ronte Holland. Ms. Holland, your full name is Briante Nicole Holland. Ms. Holland, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Holland, you may put your hand down. How are you doing, Ms. Holland? I'm doing fine. Thanks for asking, Ms. Holland. I have before me a document that is titled Jefferson County, well, that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes,
Or are these your initials on the line that state that you would like to apply for court-appointed attorney?
yes.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? And on page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes.
Ms. Holland, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Ms. Holland, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Christy Carlton. Attorney Carlton will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. What's the name? Is that? Are we finished? Now, let me get her back up here.
You need her back up here?
Yeah,
Okay, go ahead. Let's see it.
now, Ms. Ms. Swallow, you appeared before the court just a few minutes ago. And it was in reference to a fine of $300 plus court costs of $337. The state is giving you 1 day credit, which will be a total of $537. And you'll be able to pay that today?
I guess so. Then I had like or something, but cool. Okay.
Okay, all right. So stand next to the bailiff and follow her directions. Once you follow her directions, you're free to go and you have a blessed day.
Yeah, I can tell them I'm gonna go downstairs. And
Okay.
quiet.
That's fine. We had to get you back on the record because the court had previously found you indigent. Okay, who else we have? Is that it? We have Mr. Harris. Mr. Harris, you come on up. Okay, I get to it. Oh, you stand in front of the bench. Okay, you can't go to her house. I mean, well,
I babysit my granddaughter at my daughter's.
well,
That's what I'm saying. That.
well, it may be an issue. I mean, you
that's-
can't go
that's what I
near,
need to know.
yeah, it may be an issue. Yeah. You was appointed an attorney?
Yes, just now.
Okay, you might need to discuss that with your attorney.
Okay, yeah, I didn't want to.
Okay, I understand. That makes sense.
That's it's within the area.
Yeah.
Not
I understand.
to babysit her.
I understand. But once you discuss that with your attorney, but like you have to follow the bond conditions
Yeah.
as it is written.
Right.
Like I said, any violation, your bond could be forfeited, your warrant will be issued for your arrest.
Okay.
All right, you're free to go. You have a blessed day. This will conclude the call of the arraignment docket on today's date, March 25th, 2025. County Court at Law Number 2, Jefferson County, Texas, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.